Okay, good afternoon, ladies and gentlemen. As reminded, I now would like to record this videotape, this lecture for your review after the midterm exam. So you may be absent during the periods of midterm exam. However, you are required to visit my depository, as you see in Kicho Ugwaku in Korean. So you have chances to be exposed to the discussion about the cases in the last class. So we have an overview about general theory and rules concerning national import and export regulation. And I presented several cases to be pertinent in understanding the area of concern, and the court, the rules in statute form or others inferred from the cases. So on page 1A4, you see a case titled Rollerblade Incorporation versus United States, decided in 2001 Federal Circuit Court. In this case, the classification of a goods within the purview of an administration on a United States Customs Service pose an issue. And as you see, the context of a justice would be based on the common and proper meaning of terms, and also the judicial practice employed the matter to defer to the discretion of a domestic branch in higher favorance as other than the areas of law. So the Chevron rule, which has been developed in principle over scope of administrative issues and law, could be applied in later, as you see in the case, the United States versus Hager Apparel Company. And how do you connote the rollerblade in terms of a goods classification? So it is a protective device when we play on a rollerblade. So the classification would have what economic implications on business entities, and in some cases, a solo or proprietorship or partnership. You see in commercial law framework, many types of business entities, and often corporation is a notable and a representative. However, the international trade business may be conducted by solo or proprietorship or partnership. So, as a general rule, U.S. courts defer to customs interpretation of terms contained within the HTS. So, harmonize the tariff schedule. So, guideline would often be determinative and imposing. And the court, as I've said, practice a judicial deference based on the Chevron law. And also, you can see some of the technical difficulties and the preserve a administrative expertise would deserve a due respect. And also often encompassed with the justice, a specific justice. How to consider? So, as I've said, the rule is what espouses the common and popular meaning of the goods title, good title. What is a rollerblade? In usual encounter, routine days. Therefore, some linguistic basis would arise about dictionaries, scientific authorities, and other reliable information sources. And the context may be complicated by entailing accessories or parts. They must have, in that case, they may have a direct relationship to the primary article rather than to the general activity in which the primary article is used. So classification of goods under the HTSUS entails both ascertaining the proper meaning of a specific terms in tariff provision and determining whether the merchandise subject to tariffs comes within the description of those HTSUS terms. When reviewing whether the imports fits within those terms, this code uses the clear error standard. So the implication is, unless the clear error was established or imagined in any way of construction about lower code dealings, then the code exercise endorse the leeway to exercise the discretion in defining the classifying the goods. So this rule was confirmed in the case titled Universal Elects Incorporation versus United States, decided in 1997. And the court also opined the kind of epistemological or a linguistic endeavor dealing with dictionaries, scientific authorities, and others, as I said, and clarified in the case titled C.J. Tower Sons versus United States. The case comes in 1942. So this code for rollover case observes that HTSUS offers no definition for the term an access. And they saw it in due course quite proper that the try code a consulted common meaning of term. So what is necessary in definition of dictionary? Protective gear does not directly act on the roller skate at all. Unlike a roller skate part or accessory, the protective gear does not directly affect the skate operation. It's just in the purpose to protect the person who plays the roller skate. It's not physically annexed to the skate itself or any dynamic in playing the roller skate with between a skates and protective gear. So the customs service would focus on this physical attribute between the two parts and negate the finding as an accessory. What do you see? A part is an essential element, constitute in a portion which can be separated, replaced, and so forth. So Webster's New World Dictionary deals in this way to define a part, edited in the year 1988. Thus, based on the common meaning, the term part, like term accessory, must have a direct relationship to the primary article, rather than to the general activity in which the primary article is used. So we often wear a protective gear, what we call rollover, and it is not a part of component. the scene a player of roller skate, and often where the wearer would be afforded the benefit of protection, a personal protection. The impose do not attach to or contact in any way the subheading article, namely a roller skate. The imports are not necessary to make this case themselves work, nor are they necessary to make this case themselves work efficiently or safely. In this case, the most applicable heading would be 9, 5, or 6, entitled Articles and Equipment, General Physical Exercise, Gymnastics, Athletics, Other Sports. So, what subheading applies to the case would make us to see a different disposition in actual outcome of case. And also, rollerblades, imported protective gear fits within this category because it is equipment specifically designed for use in the sport of a roller skate. So the Court of Form, the decision of a CIT, the Court of International Trade, in the final event. And also other contexts to involve the international trade law dispute in the domestic dimension of the United States would concern kind of the export, a free export zone, or other institutions to facilitate the export or import. And some of finding, for example, involving the bending process, whether it could fall within the class of a substantial transformation, or it falls within the purview of a statutory provision about mere assembly without further fabrication, or some of a significant act to make it devoid of a entitlement about refund or export subsidies. Kind of a controversy would often be patterned in revolving around this area of law. You see, in the case Crosby versus National Foreign Trade Council, decided in 2000, exposed some of interesting context of federalism in the United States. As you see in the framework, a structure of a federal constitution, it will be available dual sovereignty between state and national government. And in that context, the supremacy clause of national constitution would be controlling to dispose the interplay between two sovereigns. And the case involves the economic sanction around the time of a Clinton administration in 1998. And Burma were the target country to sanction about the repression of a democratic movement in the in Burma, and it offers the basis to be exempted from the dovetail commitment. So the duties and obligations of dovetail may be waived, as I have introduced, on the basis of general exception clause, national security or public health, safety or national morals or culture. There are a scope of exculpatory causes encoded in WTO measure. And the Congress delegated a quite a wider context of a policy discretion to respond with the Burma problem. Against this mandate, the state of Massachusetts enacted the state law to prohibit the entire scope of transaction with Burma. How do you consider it corroborates with the intended purpose of Congress? Of course, that is one way to complement with the national goals. However, in this case, you see many companies what they associate with the plaintiff, National Foreign Trade Council, have suffered a great injustice. As you see, free trade was impeded entirely on the basis of this statute scheme. And also, it purpose transgressed to some extent to restrict the entirely the state authority to engage in transaction with Burma. So the state official would be statutorily barred from any trade relationship with Burma. That means to hamshackle the companies based on Massachusetts, and also controversies in legal terms would be present. As you see, the case has had a high chance to be brought into forum of a WTO. So it one kind of a domestic measure subject to WTO ambit of a jurisdiction. And often we define as a matter of law the case laws or court decision in the purview of a domestic measure. So the chance would be legally possible that the case may brought, domestic case may brought to the review of WTO. However, it is practically none of cases often, and almost always the national statute or a domestic measure be popular on which falls within the scope of WTO review, as you see. And also, the case actually would bring many points in detail about the rule of a federal supremacy, the scope of federal act, and the intended ambit to regulate. So the court often deliberate in detail to avoid its scope of overlap. That means the court often favor some of independent and genuine basis of a state government, since it is often posited to specifically to address the challenges imposed distinctively in that particular state. So many code rules, in principle, have evolved over decades around the rule of a federal supremacy. So, against other provisions, for example, equal protection or a commerce clause or contract clause, which are typical to be grounded on called a finding of unconstitutionality, the federal supremacy clause would be structured in theory and governance about the basis on condemnation of a state act. However, practically, the federal supremacy clause would not be invoked since it entails actually some of a difficult points between two dimensions of a government. So the court in this case finds the state action that comprises the ability of the president to speak for the United States with one voice in dealing with a foreign government is unconstitutional. So effective diplomacy often the goals the federal constitution likes to safeguard. So the type of a state legislation may fail the constitutional mandate. The state action conflicts with a specific congressional delegation of power to the president for conduct of foreign affairs is preempted by the supremacy clause of the U.S. Constitution. So, let us see some of details and now a brief about some fact for your reference. See on page 1A6 to 1A7, you have a gist of a court opinion and fact brief. In September 1996, 3 months after Massachusetts law was enacted, Congress passed a statute imposing a set of mandatory and conditional sanctions on Burma. The Federal Act has 5 basic parts, 3 substantive and 2 procedural. And the controlling federal law would be the Burma Executive Order number 13047, issued by a president on May 20, 1997. And in this executive order, President certified that the government of Burma had committed large-scale repression of the democratic opposition in Burma and found the Burmese government's actions and policies constitute an unusual and extraordinary threat to the national security and foreign policy of the United States. A threat characterized as a national emergency. So actually, this type of delegation would be frequented of to address the international challenge about democracy, human rights violation, what else? The Massachusetts statute bans all aid to the Burmese government except for humanitarian assistance, counter-narcotics efforts, and promotion of human rights and democracy. The statute instructs the United States representatives to international financial institutions to vote against loans or other assistance to or for Burma. It provides that no entry visa shall be issued to any Burmese government official unless required by treaty or to stop the Burmese mission to the United Nations. These restrictions are to remain in effect until such time as the President determines and certifies to Congress that Burma has made measurable and substantial progress in improving human rights practices and implementing democratic government. So, now on the essences of a federal act, and the federal act authorizes the president to impose further sanctions subject to certain conditions. He may prohibit United States persons from new investment in Burma and shall do so if he determines and certifies to Congress the Burmese government has physically harmed, rearrested, and exiled some key. The opposition leader selected to receive Nobel Peace Prize. Blah, blah, blah. What is the point of contention? So, contrary to this federal mandate, the state has set a different course, and the statute conflicts with federal law at a number of points. By penalizing individuals and conduct, the Congress has explicitly exempted or excluded from sanctions. So, how the state law conflicts with federal act? That poses a difficult question as a matter of law, which is amenable to full requirement developed by code. Now, defer to the discussion to your constitutional class. It restricts all contract between the state and companies doing business in Burma. The previous context between the state and United States persons, goods, services, or technology, even though those transactions are explicitly exempted from the ambit of a new investment prohibition, when the president exercises discretionary authority to impose sanctions under federal act. So the direction and ways of regulation may counteract with the federal mandate. And the manner to regulate the transaction in Burma is highly imposing and unilateral, and what actually catch all the scope of transactions to be impeded. And the companies operating within the National Foreign Trade Council now file a complaint. This is non-profit or corporation representing companies engaged in foreign commerce. And so the court finally found the State Act is at odds with the President's intended authority to speak for the United States among the world nations in developing a comprehensive multilateral strategy to bring democracy to and improve human rights practices and the quality of life in Burma. So we can indulge the law will admit more sublime goals, and as you see in general exception clause of a WTO, and also the Court of the United States facile recognized. Another case to make up for the previous discussion would be export regulations. You see in the case titled United States versus Donald Shattery, say 1992, which shows the context of a violation of export control. And the case also is interesting to see the discretion of this court judge about sentencing guidelines. This case involves an export of a microwave amplifier to West Germany without an export license. And this device is sensitive to make up the Department of Commerce Commodity Control List. So it is actually the subject matter controlled by the government, and the export should be encompassed with general license, and must respect the regulation about export license. And also the background about this case reveals that the Soviet Union possesses a high interest to import this device, a microwave amplifier. From 1986 through 1989, Mr. Shattery, who is a defendant in this case, sent electronic equipment, including microwave amplifiers and computer software, to Mr. Mann in West Germany. In October 1988, Mr. Mann sent a letter to Mr. Shattery requesting him to purchase an amplifier from Berkshire Technology Incorporation of Oakland, California. So, a validated license requires the exporter to file a license application before exporting commodities that cannot be exported under general license or without authorization by the Office of Export Licensing. So such commodities are included in control list. So the first point of petition would be that it should be Donald Shattery should be found not guilty, and the next contention involves the statutory ground about sentence guidelines, and the defendant points to erroneous ruling about refusing to depart below the guidelines. The U.S. statute pertinent to be applied states the one who knowingly violates or conspires to or attempts to violate any provision of the Export Administration Act or any regulation, order, or license issued hereunder commits a crime. So Mr. Shattery contends that an exportation or attempted exportation of a controlled commodity without license becomes a crime under the statute only when the exporter knows that a license is required. How do you find the merit of this defense? So the regulatory scheme often be provided beyond the strict application of mens rea requirement normally required as the criminal justice institution. Mens rea actus reus, that is also the case in the jurisdiction of the United States. So, what can you illustrate the mens requirement? What a broad term within the concept of culpability, knowledge, and plainly a factor to find a culpability, and also recklessness, negligence, and also we see an interesting approach in distinct in common law system about the degree of murder, for example, second degree murder, first degree murder. What is the essence to sustain the finding about the different types of crime? So, that is prevailing. However, you see some institution which is classed as criminal ambit about waiver of a mens rea requirement, criminal liability of corporations, and a vicarious liability would often be in the scope. So, requirement about that element would be it dispensed away to restore the public justice, for example, and in the need of a public policy to facilitate the public goals. Okay? So, individual basis of criminal law or maybe eclipsed in that limit, you see. However, that will often involve a life penalty, and generally it serves the public purpose in most favorite. So a severe class of a crime would not be dismantled in so the export control is kind of a regulatory scheme to serve dominant national security are in public causes and may be related, as we have learned, with a trade and international transactions. Mr. Shattery would violate the section 2410A in the statute. In order to establish the finding, the government was required to prove beyond a reasonable doubt that Mr. Shelley knowingly exported or attempted to export a controlled commodity without obtaining the appropriate export license, in violation of the statute in effect. Finally, Mr. Shatterley argued that the district court misapplied the sentencing guidelines by refusing to depart below guidelines. In this case, Mr. Shatterley was sentenced pursuant to guideline 2M5.1, which provides for a base offense level of a 22 if national security or nuclear proliferation controls were invaded. One of the bases of the Export Administration Act is to protect national security. Accordingly, the district judge sentenced Ms. Shetterly to 41 months of imprisonment, the minimum sentence in the applicable guideline range. So, how do you see this ruling? So the appellate court finds that the trial court actually exercised discretion, which presumes his understanding of a sentencing guidelines and decided in his own way. So the error allegedly claimed by the defendant about neglect on this sentencing guideline would be denied. Said. So in the court document, you see the opinion involving the volume of commerce involved, the extent of planning or sophistication, and whether there were multiple occurrences in determining a sentence within the guidelines. So the circuit of court found that it must review the record to determine whether the district judge exercised his discretion in refusing to depart from the guidelines. And district judge's statement indicate he considered it would no longer be illegal to export the Berkshire amplifier of the country without license, and also found it is clear that the judge used his discretion in refusing to depart. And in the case titled Daedalus Enterprises Incorporation versus Baldry, you now have a case highlights about some of important points. First, the Export Administrative Act vests authority and discretion in Secretary of Commerce, the processing of export license applications. However, this discretion is limited. So you need to see the points of distinguishing whether the discretion satisfies the level required as a matter of law. And the doctrine of exhaustion of remedies found in administrative law requires an applicant to follow all administrative appeals processes before seeking a judicial relief. So the doctrine of exhaustion of remedies, as you learn from the administrative class, also one of the pillars with the Chevron doctrine. So the available remedies should be completed in advance before proceeding to the court litigation. The Secretary of Commerce cannot unduly delay a decision on an export license application and then receive a dismissal based on the exhaustion of remedies doctrine. So initially, I planned to see other cases involving international sales contract. However, I failed to meet the time constraint. And okay, I hope you best luck. Wish best luck in the exam week. So, how do you entertain Major League Baseball? Dodgers is now here, Korean hero, and once the supervisor of Dodgers team commanded the Hyunjin Yu is overused as used. Over the Korean citizens elevated his status what is jackpot. You see in today's internet. What does it mean, jackpot? Is it the context of gambling? And also, I encountered an interesting story about KT. KT is a public company, as you see, and also it has some point of bearing to this class and law. So now, civil monitor group has played well to what? To supervise the proper way of public businesses. The secretary, who is a key figure, to be accused of failure in business judgment. However, you see the rule, as you learn in the class of commerce law, the business judgment rule developed by the Court of the United States. The rule was designed to encourage the spirit of a business director and to act proactively to frontier the business scope and make a judgment in more security. So it is one institution that needs to be considered for a Korean incorporation. So it is one of a modality we may consider to boost our economy, national economy. So the purview and perception may be spread, as you see in the case civil monitor group. So the public power may do well to interplay with kind of a cross-check and also guarantee against the miscarriage of the business purpose. However, other aspect was the impromptu to encourage the business director. The business judgment rule was once explored in the Korean court of cases. However, actually, the courts of Korea reluctant to expand the scope of application about the business judgment rule. So may turn to find the responsibility, personal responsibility of directors and officers about the failure of a business discretion, management discretion. Interesting, and advise you to have a pleasant weekend of completing the exams. See you in the next class. Thank you for your attention.